Hi, I'm delighted to welcome Garry, who has already done a little bit of introduction. I'll do a tiny little bit more and then let you take it away. Garry, your surname's Sturrock, so for everybody here, this is Garry Sturrock, and he works at the law firm Brodies in Aberdeen, who are one of Scotland's leading family law teams. There, Garry is a senior associate, and he's accredited by the Law Society of Scotland as a family law specialist and a child law specialist. He's regularly invited to present training, to share his knowledge with peers, and his articles on family law are often published in the Journal of the Law Society of Scotland. So we're very privileged to have him here with us today. And I just want to join with everybody in saying welcome, Garry. We're looking forward to your presentation.
Thank you, Fiona and Lindsay. There should also be an option, correct me if I'm wrong, Fiona, for people to send a message to panellists and hosts only.
Yes, so yeah, they can.
Yeah, if they don't want to share a question or information with the whole chat, they can send it to just us, and I will be covering those questions at the end. So please feel free to ask those questions by sending it to panellists and hosts. It gives us the opportunity to answer those questions that you might not be comfortable sharing in the group. So I want to just start off really by covering at the start of this presentation what we're going to be covering today. So you've got a good idea about the content, and then I'll go on to speak about particular areas. So I want to just start by explaining about the legal framework for adoption and the effect of adoption in Scotland. So let's bring it back to its basics. I then want to talk a little bit about the forced adoption scandal and the Scottish Government's response, to then generate some discussion to think about reversal of adoption. I want to then look at the law as it currently stands in Scotland about whether you can reverse an adoption order. I would then want to move on because it'd be interesting to look at how things have fared out south of the border and look at English cases to look at reversal of adoption in England. And then I want to look at the international approach to reversal of adoption and then consider the calls for change in Scotland. I should say really from the outset of this talk that we won't really be covering step-parent adoptions or international adoptions, both of which could be separate talks in their own right. References in my talk to the adoption process then refers to children who are placed with prospective adopters or a prospective adopter who aren't the child's step-parents or a biological relative. It includes, for today's purposes, children who have been accommodated out of their parents' care and where the prospective adopter or adopters have no biological link to the child. So let's take it back to its basics so we can understand about adoptions and how that process comes about. And let's look at the law on adoption. So the legal framework for adoption in Scotland is contained within the Adoption and Children Scotland Act 2007. Part 1 of the Act then deals with adoptions. And we need to look at it in two parts because there's two distinct processes for adoption in Scotland. Firstly, there's provisions in the Act for a child to be made the subject of what's called a direct adoption. This is where the prospective adopters raise a petition themselves for the child to be adopted. Another legal route to adoption in Scotland is for the local authority to secure a permanence order with authority to adopt, and then once that has been granted and a suitable adoption place is identified, then a petition for adoption can then be raised by the prospective adopters. Though, as the court's already determined the issue of whether the child should be capable of being adopted, which is the consenting to the child being adopted, the test for the adoption order is very different to that of a direct adoption. I think it's interesting to look at the differences in Scotland because it is quite interesting to know these different processes. And there's some research that was carried out some time ago by the Scottish Children's Reporters Administration in 2015 into the use of the direct adoption route versus the local authority adopting. if you look at it in two ways, the first way involves the burden on raising the adoption on the prospective adopters. The second one is that all of the work's really done, the legwork's done by the local authority. And what was interesting from this research, and it might have affected some that have been in this chat, is the geographical divide within Scotland as regards to the distinct processes for adoption. So looking at their research at that time, it was clear that those in the west of Scotland, so more Glasgow-based, were far more likely to be the subject of direct adoptions. So 95% of children in the west in 2015 were the subject of direct adoption, so where the prospective adopters raised the action themselves. In the northeast of Scotland, the north of Scotland, then 98% of cases were on the other side. They were children who were the subject of permanence orders with authority to adopt. So two very different approaches in the north and the west of Scotland. Anecdotal evidence really about, you maybe be thinking, well, why is there different ways of approaching this? And anecdotal evidence from the north and east of Scotland indicated that in 2015, local authorities thought at that time that they should shoulder the burden of seeking orders for adoption, especially if the case was going to be contentious. And in the west, their rationale was that a permanence order with authority to adopt should really only be sought if the adoptive parents had not yet been identified for the child. I have it on good authority now that many local authorities are shifting in their approach, and direct adoptions are becoming more increasingly common. So just looking at the adoption process generally, just so we can understand what that involves, just as a quick summary, Section 15 of the 2007 Act confirms that a petition for adoption can be sought by a prospective adopter or adopters if the child's at least 19 weeks old, and at all times during the 13 weeks immediately prior to the application being made to the court, the child is residing in the applicant's home. There's also further provisions that are contained within the Act, and these are basic. So a prospective adopter must be at least 21 years old, and I've done an article really on our website at Brodies about sort of adoption myths and dispelling some of those myths. Just as a summary, a child can be adopted by a single person, a child can be adopted by a couple, it can be a same-sex or mixed-sex couple, whether they're married, whether they're in an enduring relationship or in a civil partnership. The sad reality is that we all know that adoptions can break down, even when the child is still under the age of 16 years old. There's no easy solution to this, and it can be quite difficult for all of those involved, especially given the legal process. Given that adoption is a permanent change to a child's status, it would often involve where there's a breakdown of an adoption. That is to say, where the adoptive family feel that the child can no longer be placed with them. It often involves the child having to go back into the foster care system and then potentially being readopted by another family. So the adoption process happens again. On a more positive note, hopefully, the number of adoptions which are noted to have broken down last year decreased from 2021. So in 2021, there were 27 adoption placements which broke down. Last year, that reduced to 12 in Scotland. So let's move on, and recognising that adoption hasn't always been a fairy tale ending. Let's move on to talk about the forced adoption scandal and the Scottish Government's response. So we all know that in some situations, adoption in Scotland has allowed a unique pathway to parenthood, and it's offered many children who've suffered adverse childhood experiences an opportunity to thrive in a loving household. But we must also acknowledge that adoptions in Scotland, particularly historically, have not always resulted in a fairy tale ending for children and families. The Scottish Government publicly acknowledged that there were practices in Scotland, particularly around the 1950s, 1960s, 1970s, which resulted in babies being taken away from over 60,000 women and their fathers. These were mostly unmarried women, and the children were placed for adoption without any regard to the mother and children's own needs or wishes. And we know that as the forced adoption scandal. Following a debate earlier this year in the Scottish Parliament, the Scottish Government recognised that individuals have reported long-lasting impacts on their health and well-being, and that includes mothers and children who were the subject of these adoptions. And the government made what they say is a commitment to fully considering the issue of historical practices around adoption in Scotland. And it'll be down to you as to whether you, in your own opinion, consider that the Scottish Government has lived up to their promise about fully considering the issue, or whether there's work still to be done. The Scottish Government issued a questionnaire inviting responses from those affected by the forced adoption scandal. They asked them to share their views and insights to try and identify what support and help they might require. There's also specialist support and peer groups which have been identified, which I don't believe are as yet in place. On the 22nd of March this year, so a few months ago, before the First Minister then, Nicola Sturgeon, resigned, she issued a formal and unreserved apology in the Scottish Parliament to those affected by forced adoptions, which is, again, subject to your own personal views on this. It is, at least in Scottish politics, it's a very big move for a First Minister to issue a public apology, and it's only supposed to be reserved for the most serious of atrocities in Scotland. And as such, we are now recognising as a society that this is one of the biggest scandals that we have faced in living memory. And it's one of the described even by the First Minister as one of the worst injustices in our history. So let's think about that then. How does that affect those children who were made the subject of forced adoption scandals? What is available to those children in terms of redress and ability to take further action, for example? Let's look at then the legal effect of an adoption order in Scotland. So in brief, once an adoption order has been granted, it has the effect of removing parental responsibilities and rights from the child's birth parents, and it transfers those rights and responsibilities to the adoptive parents. So the adoption effectively terminates the legal relationship between the child and their birth parents, and that includes succession rights, the right to inherit from a parent's estate. And it also terminates the legal relationship between children and their biological siblings unless those children are adopted together. So a new legal relationship is created with the birth family, with the adoptive family. The children become the children in the eyes of the law of the adoptive parents. The adoptive parents, if they have any other children, will become the legal siblings of the adopted child, and it goes up and down the line. So up the line, grandparents, they then become the legal grandparents of the child, which affects then succession laws. So if a child is due to inherit from family members, their birth parents and the link to that family is severed, and with the new adoptive family, that new legal relationship is being created. So if you think about the way that the law works in terms of terminating completely the legal relationship with birth parents, the legislation in Scotland is intended to make adoption permanent and invariable. It's quite important to consider how judges and courts have approached this in the past. So Baroness Hale of Richmond provided quite a useful summary in an adoption case in 2008. The name of the case was Ray P. and others. She said an adoption order does far more than deprive the birth parents of their parental responsibilities for bringing up their child and conferring it upon the adoptive parents. It severs irrevocably and for all time the legal relationship between a child and her birth family. It creates irrevocably and for all time, unless the child is later adopted again into another family, a new legal relationship, not only between the child and her adoptive parents, but between the child and each of the adoptive parents' families. And she concludes that adoption then is the most serious and far-reaching order known to family law. So what is this talk then about reversing an adoption? Having spoken with the Scottish adult adoptee movement, I understand and they support the view that adult adoptees can experience a crisis in identity surrounding the link with their birth family and their new identity post-adoption. This may be particularly so for adults who have been involved in historic forced adoptions, and there have been calls from some adult adoptees for their adoption to be reversed. So what is the legal position in Scotland then? In short, there's no clear legal mechanism which would provide for the reversal of an adoption order. And I want to explore why that is in a wee bit more detail. Adoption has long been described in Scotland as irrevocable. If we look at statutes, so there's two different bodies of law in Scotland. You've got statutes, which is the laws that are written by Parliament, and you've got case law, which is the law as it's been interpreted by the courts. If we look at statute, there's only one provision in statute which actually explains about the circumstances in which an adoption order could potentially be reversed. It's contained within section 68 of the Adoption Scotland Act 2007, and it allows the highest court in Scotland, the Court of Session, to annul an adoption which is a convention adoption. So in very basic terms, an adoption of children from countries abroad where those adoptions are legally recognised in Scotland, but where the court holds that that adoption is contrary to public policy. But there's no statutory mechanism which considers how an adoption order which is granted in Scotland can be reversed or revoked in any other circumstances. So that then leads me to think about whether we can look at the common law for remedies. The common law is the law that's been interpreted according to the courts throughout Scotland. There's an important legal text in Scotland, which is the law relating to parent and child. It was written by Wilkinson and Norrie, and they explained in their book their view that a court order in Scotland might be set aside in an action for reduction. It's a particular legal mechanism, but there's no clear judicial authority considering the issue. They then go on to say that generally the right of review by reduction is a common law right which has existed for a very long time, and it's a mode of review which can be taken away, or can't be taken away, except by statutory enactment. And that right is held to have been so important that it was confirmed in a later case of Mathewson against Yeaman. Just checking a wee message in the chat, if you just bear with me a second. Thanks. It then goes on to explore a wee bit more about other cases. And the reason I'm explaining this is to try and let you understand how the Scottish courts have approached the issue of reversal of adoption. There's an old case, it was back in 1948, which was a case called J&J versus C's Tutor. This case concerned an action by individuals who sought for an adoption order to be reduced in respect of a child they claimed had been obtained on the basis of an essential error as to the child's physical condition. So they were the adopters of this child, and they say that they had been this child had been placed with them on the basis of fraud. They were given wrong information about the child's medical and physical condition. And the court held that in that circumstance, it's not open to adopters to seek reduction of adoption on the basis of alleged essential error or misrepresentation regarding the child's health, physical state, or other qualities about the child. So this legal text I referred to earlier, Wilkinson and Norrie, they then go on to say that the nature of adoption points to a severe limitation of the grounds on which reduction could be considered in Scotland, and importantly, perhaps, in their words, to its virtual exclusion. Another case more recently was in 1995, and that was D against Grampian Regional Council. And in that court, the court was referring to grounds for revoking the right of natural parents who've then married to adopt their own child to legitimise it, but that's no longer a ground in law. But on speaking about adoption generally, the court said an adoption order once made is revocable only in circumstances which have no practical effect upon the child's day-to-day life. So it provided sort of further support for the view that there's no clear mechanism for reversing adoption in Scotland. In a later case then, Cameron against McIntyre's executor, that was a case in 2006. The court had to deal with a situation where it didn't even have the power in the first place to grant the adoption order. So in this case, an adoption order was granted on the adopted person's 21st birthday. And in that situation, the court held that there was a circumstance where the adoption order itself was a nullity because of the fact that the adoption order should never have been granted in the first place, because a person who's over the age of 18 cannot be adopted. So the court considered that in this very unique situation, the court was able to reduce the adoption order. However, this was quite a unique situation, and the courts in Scotland seem to have closed the door to other avenues for adoption orders to be either revoked or reduced. In that case, I spoke about Cameron against McIntyre's executor in 2006. The court basically said there's strong policy reasons for treating adoption orders as sacrosanct and only permitting their reduction in extreme situations, which are probably theoretical rather than practical in their significance. But the court didn't go on to say whether reduction, which is setting aside of an adoption order, could be an appropriate remedy where the adoption order was granted against the principles of natural justice. And one would think, arguably, that that's a very strong ground. So I would give my view that the door was left open for judicial consideration of the issue. In 2005, there was a group that convened called the Scottish Adoption Policy Review Group, and they considered the law on adoption in Scotland. In their report, it said there should be no statutory extension. This was their recommendation. There should be no statutory extension to add grounds for revocation of adoption orders. And in their report, they stated that adoption orders involve a change in a children's life status for life, even in exceptional circumstances of fraud or grave irregularity. This change in status should not be revoked. The question of damage is a separate issue. The irrevocable nature of adoption orders is important in underpinning the security and stability that adoption provides. It also emphasises that adopted children are in a similar position to other children in Scotland. So this was a clear message from the Scottish Executive in 2005 that they were not willing to consider making legislation which would allow an extension of the grounds upon which an adoption could be reduced. But things have moved on quite considerably. We're in 2023 now, and we're now recognising that there are grave injustices in Scottish legal history which involve adoptions which should never have been granted. So are the courts going to open their mind, and are the legislator going to open their mind to the need potentially for changes to be made? I think it's important then to look at the position south of the border, because I think if you look at the English law cases, there's a bit of a movement, shall we say, in England, which would suggest to me that there may be calls in Scotland for a similar move and a more flexible approach to the issue. I would argue, just looking at the case law in England, there's been a more open approach taken. Back in 1948, again, we're going right back, case of Skinner v. Carter, doubts were expressed by the Court of Appeal as to whether there were any appropriate proceedings in which an adoption order could be set aside. But since then, there's been subsequent cases where it's been allowed in limited circumstances. There are cases where the court's allowed an appeal against the maker of an adoption order out of the statutory time period. And there's also been cases where the court has allowed an adoption order to be set aside where there's been irregularities in the process. I'm going to give you an example. So in RV Leeds City Justices in 1951, the court quashed an adoption order on the grounds of procedural irregularity because the father of the child, his address had been concealed, and he wasn't notified that the adoption order was being sought. Again, in Scotland, the court seemed to have said, even in the circumstance of grave irregularity, we won't set aside an adoption order. This was a very different approach. In R v Liverpool City Justices in 1959, the court quashed an adoption order where the statutory provisions hadn't been properly considered. So the court hadn't properly considered the legal test for granting of the adoption order. In 1970, another case then, Ray FR, an infant, adoption orders were set aside because the petitioners had failed to take reasonable steps to find a natural parent. And so it's clear that the court, in at least south of the border, the courts have recognised that where the adoption process hasn't followed the proper steps, they can look at a setting aside of the adoption order. But there's no general rule that can be gathered from the English cases about the circumstances on which an adoption order can be set aside. And it's been very fact specific. The leading case on this really is a case called Ray B, Adoption Order, Jurisdiction to Set Aside. So the name, the clues in the title, it's considering about the jurisdiction to set aside an adoption order. This was a case in 1995. And in that case, the court declined to set aside an adoption order some 35 years after it was granted. In that case, the applicant was the adult adoptee, and he sought for the adoption order to be set aside on the death of his adoptive parents. The adoptee was born to a white English mother and a Muslim Arab father, and he was adopted by an Orthodox Jew couple. The couple had been wrongly informed the child was Jewish, and so the adult adoptee sought for the adoption order to be set aside or revoked. The court basically said in that case that it doesn't have any power to set aside an adoption order which had been regularly made in accordance with the proper procedure by reason of a misapprehension or a mistake by the parties as to the race, ethnic origins or religion of the child or natural parents of the child. But the court in that case didn't close the door to adoption orders being set aside once they'd been made. The court actually confirmed that if there was a procedural irregularity that amounted to a denial of natural justice, then the order may well be set aside, going much further than what the Scottish courts have done. It also concluded, for example, that a necessary consent, for example, a birth parent's consent, if that was vitiated by a misapprehension, and if it was in the best interest of the child to do so, it could lead to an adoption order being set aside by the court. I say this with caution, though. The courts in England and Wales have said, yes, we're willing to set things aside, but there have been a succession of cases where they've been very reluctant to use that power. So I'll give you some examples to show you how potentially harsh the courts have been to this issue in England and Wales as well. So in 2009, there was a case called Webster against Norfolk County Council. And in this case, the children were removed from their parents' care on the basis of an assessment which concluded at that time that the children required protection from parental abuse. The parents sought leave to appeal the adoption order some years later on the basis of medical evidence that they'd obtained which said it might vindicate their innocence. The Court of Appeal expressed, in their words, sympathy for the plight of the birth parents, but they rejected the application and they held that there was public policy considerations relating to adoption, which simply make it impossible for the court to set aside the order, even if the birth parents were able to argue successfully that they have suffered a serious injustice. So the court reiterated then that the inherent jurisdiction can only be exercised to revoke an adoption order that had been lawfully and properly made in highly exceptional and very particular circumstances. It could be argued then that a more recent English case of PK and Mr. and Mrs. K in 2015 provides a ray of hope that the courts in the UK are prepared to revoke adoption orders in quite extreme circumstances relating to welfare of children. In that case, PK against Mr. and Mrs. K, the judge basically revoked an adoption order which had been made 10 years prior, where the child was 4 years old. The child had been sent to Ghana 2 years after the adoption order was granted to live with extended members of their adopted family, and the child was the subject of significant abuse. The child returned to England and was reunited with her birth family some years later. And in that situation, the judge allowed reversal of the adoption, and which again had been virtually unheard of before. The court again expressed some hesitation and to try and close the door so that there wasn't any further consideration of can we extend beyond the exceptional setting aside of adoption orders. The court expressed some fact-specific circumstances to say it's only in exceptional cases that this would be considered. It's also important to consider that at the time that the adoption order was set aside, the person was still a minor at the time. Our focus today is really on adult adoptees, and it focuses on, in particular, the forced adoption scandal. So that case wouldn't be helpful in this situation. But if we look generally across the United Kingdom, then what can we conclude? Adoption orders and setting aside of adoption orders are rare, if at all possible. There's no general right in Scotland for adult adoptees to disenfranchise their adoptive parents, as it's known in the United States. I want to then think about, before we generate a discussion then, about the international approach to this. Other countries across the world, to give you some insight, have approached reversal of adoption very differently. In all states and territories in Australia, discharge of adoption orders is covered by express statutory provisions, and it's basically capable of being done on the ground that the adoption order was obtained by fraud, duress, or other improper reason, or that there's some exceptional reason why the adoption order may be extinguished. In Victoria, for example, an adoption order can also be discharged where there's been a breakdown of the relationship between the adoptive parents and the adopted person. In New Zealand, the Adoption Act 1955 confirms an adoption order can be discharged on the basis that it was made by a mistake as to a material fact or in consequence of a material misrepresentation to the court or to any person concerned. Let's look again across the globe. South Africa, their legislation allows an adoption order to be rescinded if there's some flaw, such as the failure to obtain parental consent and if rescission of the adoption orders in the child's best interests. Let's look at the United States then. There's an evolving body of case law on revocation of adoption orders in the USA, but it still remains limited in nature, like in the UK. The main body of cases in considering breakdown of adoptions for adult adoptees in the US has been on the basis of wrongful adoption, which is a remedy, almost like a pecuniary remedy for seeking damages, where adoptive parents have been misled about the health or other attributes of the child. There's also some states where there's emerging case law about revocation of adoption at the behest of an adult adoptee when it's pursued on the basis of the breakdown of the relationship with their adoptive parents. An interesting approach, which is a more restricted approach, but is just something that is worth considering, is in the Netherlands. There's a window where adult adoptees aged between 20 and 22 can seek for an adoption order to be revoked. And the consequences of that means that the person who is no longer the child of the adoptive parents then become the child of their original legal parents. Bolivian law, simple adoption can be revoked where the physical, moral or mental well-being or the patrimony of the adopted child or the adoptive parents is compromised. And finally, then in Japan, there are circumstances in which adoption orders can be set aside. So there is ample authority across the globe for recognising that there are circumstances in which children can be made the subject of adoption orders, and those adoption orders later being reversed. Is change likely in Scotland then? So let's looking forward then. Is change to the current very restricted basis for revocation of adoption in Scotland possible? The Scottish adult adoptee movement is continuing to gather support from MSPs, and they've produced a paper calling upon the Scottish Government to enact legislation to vary the law, specifically to permit adult adoptees to leave their adopted status by legal means and to revert to their birth identity. Revocation of adoption is, in my view, likely to be a very topical issue in the future, especially given the continuing dialogue surrounding how the injustices of historical forced adoptions in Scotland might be addressed. Whether there's going to be radical change to the law anytime soon is uncertain. Any change to the law would, in my view, require legislation to be enacted by the Scottish Parliament, and that would be legislation requiring or allowing adult adoptees to disenfranchise their adoptive parents and to seek reversal of adoption. There has, at least historically, been a fierce opposition by the Scottish Executive to the idea that adoption can be reversed. Whether in light of the recent recognition of the injustices of forced adoption in Scotland and the formal apology issued earlier this year, whether there is any appetite for review by the Scottish Government to take things forward and look at reversal of adoption remains to be seen. So I want to open the floor out really just to see if there's any questions, and I'm just having a look in the chat just now. Someone's mentioned really in Australia, if you want an adoption order, generally the rule is that you will get it, and that seems to be anecdotal evidence from those who've been involved in that in Australia. And a note from the information that's been provided in the chat, that is especially so if a child has been involved in what they refer to as the forced adoption scandal and during that era. Yes, I agree with that on looking at the case law and the approach in Australia. They are far more recognising, probably one of the most forward-thinking jurisdictions in the world around recognising forced adoption. They recognised that this was a practice and an issue far earlier than we did, and they've taken action far before, well in advance of this being considered by the Scottish Government. Another comment was that if someone gets an adoption discharge, are they automatically legally reconnected to their birth family? My understanding then is that where there have been adoptions that have been reversed, the child reverts to their original birth identity, and that's what seems to be happening in those cases. I wonder if anyone has any thoughts on the approach in Scotland, what maybe needs to be done going forward, or just has any views to share about the law as it currently stands and what you might need to do forward. Lindsay and Fiona, it might be useful to hear your views on things.
So I've put a question in, but so I'm going to, now I'm saying it, I'll just say it to you. So one of the things is because obviously we've looked at this quite a lot, and we had to look at little adoptees and things, guys. So you know the story. But is there, or could you see a way where the law would acknowledge multiple family relationships for care experienced people? I mean, that's, and I tell you why, before I let you answer. One of the adoptees in America brainstormed me one day with one of the most amazing things I'd ever heard. And I won't say her name, but the credit goes to her. And she had said about care experience passports to keep where you've been, what you've done. And it led me to realise that actually for adopted people and care experienced people, we have multiple families. And the other one is when you were talking about adoption disruptions, were you talking about legal disruptions? These disruptions were these, did somebody go out and go, right, this has been disrupted, so legally we're going to put, you know, sort this out, or were we just putting them back, children back in care, and obviously waiting then for another adoption? And that's my question.
Yes, so answering that, the last question, that's an easier one. The statistics seem to cover situations where there's been a breakdown in that placement and the child has to be returned from their adoptive families, which I always find to be very, very sad and very difficult situations where children have been placed with these parents, and try to choose my words carefully, where people have children through natural conception. You don't really think in your eyes or in your mind you've got a choice to hand them back. There's nowhere to hand these children back to. So I always find it difficult to try and understand and comprehend situations where it's, you know, it could be seen that children who are the subject of adoption can be sent back because, you know, the law is clear. You are now their legal parents and you have the full responsibilities and rights in respect to those children as a birth parent. So it shouldn't be an expectation that if things don't really work out, the child could be returned. Just answering Dawn's questions, how many breakdowns and not readopted just get over 18? Yes, there can be situations where those adoptions break down in adolescence, and then there's nothing done about it until later on, and by the time the child's 18 there can be nothing done. As we've spoken about throughout this seminar, there's no legal mechanism for adoption. You've got that window until the child's 18 for them to be readopted, and that could actually theoretically involve the child being readopted by their birth parents. There's nothing in the law to say that a child cannot be readopted by their birth parents if the placement broke down, and if the adoptive parent, the birth parents were in a place that they were able to have the child rehabilitated back to their care. Going back to Fiona's point then about recognition of multiple family relationships, there are currently ways in which that's being done, and it's not quite the conventional route. So there are children that go through the foster care system, so they're placed with foster carers, and it's identified as their forever family, but they don't go through the full adoption process. Those children are made the subject of permanence orders. What then happens is their parents' parental responsibilities and rights are taken away from them, save for the parental responsibility to have contact with them usually. But those rights are then transferred to the local authority usually, or sometimes the foster carers. But the difference with that is that there's not an adoption, so there's no new legal relationship with anyone. The original legal relationship with birth parents isn't completely severed. All that's severed is their parental responsibilities and rights. So they still have that legal relationship with their birth parents in the sense of inheritance, siblings, they still have a legal relationship with those siblings. They're still recognised as their family. That is one way in which multiple family relationships at the moment can be recognised. But things are evolving, and it's a really interesting question. Is there a mechanism? No, there isn't a mechanism in Scotland. We've got this sort of binary approach to adoption in Scotland, whereby your relationship with your birth family is terminated completely, and you have this new relationship with the adoptive family. Are there circumstances in which, for example, it might be in children's best interests to have more legal ties with their birth parents? That's an interesting point. It would require legislative change to change radically the way that adoption works in Scotland. Because of the way the legislation is enacted, it means a complete change of that family. And it would require the government to look at changes to the legislation if they were to make a different way of adoption working. Let's look at some of the questions. How many? Yeah, the question to everyone from Peter about forever family, I completely agree with that. We have to recognise, and as I've said from the start of this, adoption isn't always a fairy tale ending for children. I've also explained that adoptions do break down. And as sad as that happens during a child's childhood, adoptions can break down. So I don't think it can always be described as a forever family. I think we do have to be careful, and I think social work and all professionals involved in adoption do need to be a bit more mindful of language used in adoption. I'm still seeing really old-fashioned language, which will surprise a lot of people, being used like a child being claimed. You know, a child can be claimed for the rest of their life. And I'm thinking, a child's not an object to be claimed. And that sort of outdated language doesn't really have a place in 21st century Scotland when thinking about adoption. And knowing about how adoption hasn't always been a positive experience for people. I don't think claim and forever family, given that breakdowns can occur, forever families and that type of terminology and language isn't always helpful. Just looking, sorry, at some of the other points and questions. About Joy has said about parents don't think about returning them, and it's true. If we look at real life experiences, how many people, you probably know people that have said, God, these kids, I'm at my wit's end with my kids, but they've never once said, this isn't really working out. You know, what can I do? And where can we put them? Whereas I have to say, in my experience, we've had a couple of situations where adoptive children, and I know of cases where adoptive parents have said to the local authority, we can't cope with this child anymore and the child's going to have to be returned. And my first question always, returned to where? Because at the end of the day, you're that child's legal parents. You've accepted from the outset that you're going to be responsible for that child according to the adoption order for the rest of their life. So it is quite an emotive subject, particularly for those that are in the chat today. There was also mentioned then about there needs to be a distinction between adoptees seeking self-determination when applying for legal undoing of adoptions and adopters reneging on parental duties when judgments are made. Yes, there are, and when I spoke about some of the cases where a reversal of adoption has been sought, there's been different situations. One where it's been the child who's the subject of the adoption, the adoptee, who sought for reversal of adoption. There's been situations where the prospective adopters or the adopters, once the adoption order has been granted, have sought for that order to be revoked or set aside. And in Scotland, it hasn't really made a difference as to who's applied for it to be set aside. The answer seems to be no at the moment.
Can I ask again about this point, as I'm really unclear what the distinction is between a breakdown and
Yes.
which would make a possible further adoption possible.
Yes.
So presumably at that point, at a breakdown, it has meant that that adoption does get resolved or reneged or set aside or something. I think that's the kind of confusion.
Yeah. So what seems to happen in these situations, the stats that mention breakdown of adoptions is where a child is placed with an adoptive family, an adoption order is granted. For whatever reason, the family say that the adoption the placement with them has broken down. The child can no longer live with them. What then happens is the child is then put back into the system, as we call it, or into the foster care system, and the local authority then have to consider options for that child's future care. Is the child going to be staying in permanent foster care? Can they be rehabilitated to their birth parents? Or can the child be made the subject of another adoption where they're placed with another prospective adoptive family and a new adoption order is granted? If a new adoption order is granted, what that essentially is asking the court to do is to revoke the rights of the first adoptive family and transfer them to the new adopters. Does that make a bit more sense, Lindsay?
That makes sense if the child is readopted, but that sounds as if the rights and responsibilities remain with the first set of adopters
Yes.
until something happens. So if one of the first two options happen, then what happens to the original adoption order?
So if an adoption placement breaks down a child, if they're not readopted, would still remain the legal child of the adoptive family. A child may never be the subject of a second adoption order. The child may, in my words, languish in the system. The child may be in foster care. They may have no permanent sort of status about where they're going to be going forward. And that's why it's such a difficult situation, because there can sometimes be no legal certainty for that child going forward. They've been made the subject of an adoption order. Their birth parents' parental responsibilities and rights have been severed, but they're no longer living with their adopters.
Yes, it sounds really difficult. Thank you.
Sarah Louise.
Hi, Gary. Nice to see you. Well done for coming on. That was amazing. Thank you.
Thank you.
I just wanted to ask, as an adult adoptee myself, what legal right does an adoptive parent have towards a descendant of an adult adoptee that has since become estranged with an adoptive parent and has no clear legal pathway to that child?
So can you maybe explain the sort of the link in terms of, like, so I can understand the family sort of dynamic, like give an example of that situation?
Well, I can't really, but it's more a sort of broad, sort of kind of really for other adoptees adoptees who become parents, but
Yes.
then are estranged from the adopter parents themselves.
Yes.
Understand? So
Yeah, so an adult adoptee is estranged from their adoptive parents.
yes, and
They have a child.
And then they have a child.
Yes.
That comes back into the system.
Yes. So what I'm trying to find out really is what is the legal pathway for an adopter parent if, for example, they estrange from the adult adoptee but want to have contact with the child.
Yeah. So they are, so this is grandparents then that are looking for contact with a grandchild that's in this the system that's basically
adoptive grandparents.
Yes.
Of
so
the adult.
adoptive grandparents, and they want to have contact with
Yeah.
and is it an adult child or a child under the age of 16?
It would be a child under the age of 16. So
grandparents have no automatic responsibilities and rights in law. So they would have to apply to the court to ask for an order for contact. They don't have automatic responsibilities and rights to have a relationship with the child. And if a parent of a child was not permitting them to have contact with that grandparent, then the person who is the grandparent would have to ask the court to make an order to regulate that relationship. I've dealt with a few situations where there's been grandparents that have been seeking contact with their child. One of the most important ones, or one of the most important concepts, is often about the relationship between the grandparent and their child, when it comes to how that relationship goes. Because if the courts are convinced there's a lot of toxicity or negativity around that relationship, they will often say this is not in a child's best interests to have that contact.
Yeah, okay.
Gary, I just want to say thank you. Honestly, from the moment we met you to today, it's been a journey. And, you know, I came to you one day like a maniac, giving it, well, I'm really angry about the law. And, you know, you've sat down, you've given us the time, you have explained it to us, and you have come here today to explain it to so many more. And I'm so grateful. And you can see the claps and hearts that are coming up. You know, it's fantastic. The chat has been, you know, you've given so much that the chat has just opened up, and you know, it's given conversation. I hope that in the next, well, we'll see. We might possibly see a difference, but hey ho, Gary, you know, I'll be in touch.
Yeah, no, I'm more than happy to help, and I'm delighted that people have engaged, and there's been a lot of questions as part of the chat. I hope it's been helpful. If anyone has any questions just on adoption, about any questions like Sarah Louise did about grandparents, their sort of rights, any burning questions, drop me an email, and I'm quite happy to just give you a wee pointer on the law.
Thank you so much.
I'll drop my email address in the chat just so that you can get in touch if you need to.
Fabulous. Thank you, Garry, so much. And a round of applause. You're amazing. Thank you so much. Thank you.
You.